Guten Morgen. I have a little bit of a cold, so excuse me. Thank you, Chris, and to all the organizers for putting this event together and for inviting me to address this group of impressive thinkers. We're here as part of a continuous tradition of more than 6 centuries. Long before budget airlines and Ubers, European scholars lived what they called the peregrinatio academica, the academic pilgrimage. A student might begin in Paris to study theology, then go to Bologna for law, and then move north to Heidelberg to study mathematics, following not a curriculum, but a constellation of teachers. And professors, of course, did the same. Abelard attracted academics to Paris. Erasmus moved between Rotterdam, Basel, and Venice. Scholars crisscrossed a Europe that was intellectually far more integrated than its politics. Vienna was very much part of that map. Since the founding of the University of Vienna in 1365, 271 years before Harvard, America's oldest university, people have been making the journey here in search of arguments, ideas, and a good fight over footnotes. Chris invited me here because he thought my ideas were something of science fiction and hoped the conference would prove me wrong, that this was a good idea. So I appreciate that. In coming to you today, I'm taking my place in that long line of scholars who have packed a few books, crossed a few borders, and arrived at a European university hoping to leave with more questions than they brought. Thank you for having me to this cradle of knowledge. I'm very much looking forward to leaving with those questions. In the hopes of kicking off the day, let me offer a few of mine, one of which will be legal persons as directors, and then a couple of other things, hopefully, that are related to that and interesting. Take them for what they're worth. Our topic today is, of course, corporate boards. They are an interesting phenomenon, but not an obvious one. Corporate boards are artifacts of the politics of early corporations, which were not simply private businesses, but creatures and extensions of the state, doing state business, building bridges and canals, outfitting ships, financing governments. These early companies bear almost no resemblance to NVIDIA, Alphabet, or Apple, yet our governance model comes from them. Take the Dutch East India Company. It had a board, but the reasons were purely political. The Dutch rolled up many regional trading companies for scale efficiencies to compete with global rivals. The solution to political rivalry was a board of governors that looked less like a modern supervisory board and more like the US Congress, representatives from each provincial trading company to ensure a say in the whole. It was monitoring, but of a political variety. When America started, most of its institutional ideas, except for the most important one, putting individuals at the center of the social project, came from Europe. The board was one of these. Early American corporations were uncommon. At the founding, there were just a handful. Like their European forebearers, they were state operations, building a bridge over the Charles River, running a turnpike, operating a bank on a special charter. They had boards because that was the model of the day, and because they too were deeply entangled in politics. Consider one of the first US companies, the Society for Establishing Useful Manufacturers. Alexander Hamilton founded it. It was an early experiment in what we today would call industrial policy. To compete with European manufacturers, Hamilton proposed the government help build a manufacturing city at a waterfall in New Jersey where power would be cheap. America needed industry, and Hamilton, the great believer in centralized power, didn't think markets would create this quickly and at the necessary scale. Congress, run by his enemies, the Jeffersonians, leery of direct government ownership, said no. Hamilton, being Hamilton, persisted. He pivoted to a private company that would be run by politicians and funded through indirect political channels. Logically, being a quasi-governmental entity, it adopted the political board approach used in European corporations, a group of notables standing in for constituencies, trying to steer enterprise in the public interest. It didn't work. William Dewar, the first head of the board, mismanaged the company and stole from it. Other board members encouraged speculation to drive up the price of the stock. The whole thing collapsed. But notwithstanding this cautionary tale, boards have been ubiquitous ever since, especially since the mid-20th century. Henry Ford and Andrew Carnegie, two of the last century's titans, had no use for them in the modern sense. They didn't want meddling in what they knew was the right approach. They were run as partnerships, despite enormous global scale. By the 1950s, shareholding democratized and ownership dispersed. At this point, the board served as a kind of useful intermediary between millions of small shareholders and the organization men who ran American companies. Of course, today's companies, especially the so-called Magnificent Seven, that's Alphabet, Amazon, Apple, Meta, Microsoft, NVIDIA, and Tesla. And by the way, they have a combined market value of more than $20 trillion. They resemble Ford Motor Corp and Carnegie Steel of 1900 much more than they resemble firms of the second half of the 20th century. Elon Musk and Mark Zuckerberg are the new titans. For them, boards are an afterthought. We have returned to a world of concentrated power, founder CEOs, and industrial empires, now at planetary scale. That alone should give defenders of boards some pause. All of this to say, the board is a historically contingent solution to a political and organizational problem. It turned out to be a good idea, at least good enough to survive, which tells us something about its value. But survival in law is not just about what works, but about what those in power can get away with. And boards are not at all necessary to run a business. We could just as well have businesses run by one person, defeasible at any time by a vote of its owners. We could have AI-driven governance system. We could have governance firms, as I'll talk about in a second. We already have alternative arrangements in sole proprietorships, partnerships, and LLCs. And yet for big companies, boards are now how most business is done, and regulation of boards is largely what we mean when we talk about corporate governance law. Before we talk about how that regulation goes astray, in my view, we should pause on why governance matters so much. Nick Bloom at Stanford and his co-authors show a surprisingly large share of gap in firm performance, and therefore performance across countries is really a gap in governance. The US has roughly double the economic production per capita of Europe, not because Americans are smarter or harder working, but in large part, Bloom argues, because of differences in how firms are governed and managed. He created the World Management Survey, a series of structured double-blind interviews that score firms on monitoring, target setting, and people management. Using this, he finds enormous dispersion in management quality across and within every country. The United States performs better than every other country, not because it lacks poorly run firms, but because it has fewer of them. The long tail of badly governed firms is shorter and thinner. Where that tail is fatter, where more firms have weak monitoring, vague targets, nepotistic personnel policies, aggregate productivity and firm valuations are lower. Crucially, this bad tail is dominated by smaller family-owned and, of course, state-owned firms. Their data shows that firms controlled by founding families, especially where control is passed automatically, score systematically the worst on management practices than dispersed ownership firms. And more on this in a bit. Most of the value lost in the world is not lost in headline scandals at global giants. It is dissipated quietly in thousands of smaller family firms with weak governance, poor monitoring, and inherited control. If we care about growth, innovation, and resilience, the design of governance, who sits on boards, how they're constrained and incentivized, and whether they can be replaced turns out to be one of the central economic questions of our time, not a technical footnote. What then can law do here, and how does this relate to our topic? We should acknowledge that the answer is maybe not much. Some differences across firms or countries may be cultural, as unsatisfactory as that label is. Some may be path dependent and contingent on things like education systems, professional norms, and the role of other institutions, the press, social clubs, religious organizations, tolerance for risk. Law may be a rounding error on these, or at least it has to take them into account. That being said, law does something crucial. It defines what's even possible. It sets the menu. So the question I want to ask is, what should law say about corporate governance? And what does that say about boards? For more than 2 centuries, corporate boards have looked essentially the same. A handful of part-timers meeting a few times a year, charged with supervising enterprises that operate at global scale and breathtaking speed. Alexander Hamilton could walk into a boardroom today and feel right at home. And that's the problem. We've spent decades trying to make this structure work. We've changed independence rules, tweaked committee charters, rewritten liability standards, imposed layers of oversight, and issued binders of best practices. Yet the core constraints remain. Directors are often brilliant, accomplished people, but they're also outsiders with limited time, uneven information, and weak incentives that often pull in the wrong direction. The result is a governance model that works well enough until it doesn't. And when it fails spectacularly. Examples from my country: Enron, WorldCom, Lehman Brothers, Theranos, FTX. The list is long, and so are the social losses. The causes are multiple, of course, but failures of governance are apparent in all of these, if not the primary cause. In our article, and then our book, Steve Bainbridge and I asked a simple question that somehow no one, at least on my side of the Atlantic, had asked. Why must the board be a group of individuals at all? Corporate law in every US state and in many countries, but not all, I learned when I looked at the program, requires directors to be natural persons. But nothing about the board's actual functions, strategy, monitoring, risk oversight, hiring and firing CEOs, logically depends on that assumption. So we propose a different model: board service providers. Imagine not 12 part-time individuals legally in charge of a company, but a professional firm whose entire business is governance. The board becomes a they, not a collection of he's and she's. Imagine being able to hire a governance the way you hire an auditor or a law firm, drawing on deep specialization, full-time attention, industry expertise, and reputational stakes much larger than individuals. Consider this last point. When people hire lawyers, they usually hire firms. Why? Because when they do so, they get higher quality. After all, when a lawyer does work while employed at a firm with 1,000 lawyers, they're wagering not just their reputation on the work, but also a bit of the reputation of the other 999 lawyers. Knowing this, these other lawyers will engage in monitoring of their work, be it ex ante, ex post, or what my colleague Saul Levmore calls ex middle. That raises quality. Of course, this doesn't come free. Hiring a law firm is more expensive too. The point is, we leave this trade-off of price and quality to clients. We don't allow businesses to make the same choice, with board members at least. It's as if the law says, when you're hiring a lawyer, you have to hire a sole proprietor. And the client says, well, why can't I hire a law firm? And the state says, well, that's the way it is. Could McKinsey Governance or Boards Inc. run a particular firm better than its current board, subject to the same fiduciary duties and legal constraints? Well, to quote a great European, Michel de Montaigne, what do I know? But I think we should find out. The idea follows directly from Ronald Coase. As a Chicagoan, I'm contractually obligated to mention Coase in every talk. In The Nature of the Firm in 1937, Coase asked why we have firms at all. In The Nature of the Firm, he said, economic cooperation is organized inside firms rather than entirely through markets because of a trade-off between the costs and benefits of hierarchies and markets. In hierarchies, things are decided by fiat. In markets, by prices. And we could organize all economic activity through prices and markets rather than through firms. The result today of the Coasean trade-off is that Apple buys manufacturing services from Foxconn in China when it could do it all itself. And virtually every firm buys at least some of its accounting, legal, and strategy services from other firms. But in the United States, governance services, board services must be purchased from natural persons, loosely stitched together in the modern board. Why shouldn't they have the option of buying board services from firms? One of the upshots is that it would create something we've never had, a market for corporate governance itself. We sort of have one today. Companies that are badly governed tend to suffer in product and capital markets. In their famous work, Frank Easterbrook and Dan Fischel note this, arguing that, quote, the best governance structure cannot be derived from theory. It must be developed by experience. And that, quote, markets bring home to managers most of the costs of their suboptimal performance. Most is the important word here, and I'll come back to that in a second. The problem is that the market for governance is confounded by everything else. A firm with a fantastic product may succeed despite bad governance. A firm with excellent governance may struggle because of industry shocks. The signals from the product market and the governance market are intertwined, and that makes it difficult for firms and investors to learn what governance structures really work. In our model, governance becomes a separate market. The value of a board service provider's work would be measured in part by the market price for its services, and if it was publicly traded, by its own stock price. Is company X well run? We can look at its stock price and its profits. But in a world where it hires a BSP, we can also look at the track record of the governance firm and its market price. If a BSP underperforms, shareholders don't need a proxy fight. They simply hire a better one. If a company needs sharper oversight, deeper expertise, or a longer-term strategic view, it can select a BSP designed to deliver exactly that. Importantly, this model is not ideological in the war between shareholders and managers. BSPs could be set up to be elected every year or in the corporate charter every 3 or 5 years. It simply makes whatever governance regime a firm chooses more effective, more accountable, more measurable. It replaces structures born in the 18th century or the 16th century with institutions built for the 21st century. And in its simplest form, the idea is less radical than it sounds. At a minimum, it could mean that the current board of, say, Boeing, simply incorporates as a group. Cooperating in this way instead of via an ad hoc arrangement would let them hire staff, build in-house expertise, and reap economies of scale. Ironically, it might make legal oversight easier. Courts might be more willing to impose meaningful monetary damages on a BSP than on individual part-time directors. Not only is the idea of the board itself something of a fetish, so too are the increasing intricate rules about how boards operate. Consider an example from my country involving Meta. Its board approved a modest pay increase for its members, about $30,000 per year, and the directors were all billionaires. Peter Thiel, Mark Andreessen, and Reed Hastings as examples. There's a conflict of interest in board members approving their own pay, so under Delaware law, it would ordinarily be subjected to a searching judicial inquiry, the so-called entire fairness test. Delaware also permits a cleansing vote of disinterested shareholders. Meta's CEO, Mark Zuckerberg, takes no pay as a board member, and he owns more than 60% of the voting power in Meta. So he is effectively the only shareholder whose approval matters. He approved the pay. End of the matter, right? Wrong. Meta did not tell its shareholders in advance that Zuckerberg was going to approve the deal, only that he approved it after the fact. On this basis, the case in Delaware, there was a case, survived procedural challenges and headed towards a trial. A fight over a few $100,000 in pay for a bunch of billionaires was going to cost the company millions in legal fees. Good for us who teach lawyers, bad for the world. The case settled. Anyone who defends corporate boards in the current state of corporate law, at least in the US, has to grapple with the absurdity of cases like this. To me, it suggests we lawyers have lost the plot. We are worshiping the form of the board and the ritual of approval rather than asking hard questions about whether the institution is doing what we need it to do. Encourage economic cooperation at scale at the lowest possible cost. Before turning to another related idea, let me just give you 2 caveats. First, and this goes to Chris's project about comparative law, and me as an American here lecturing a bunch of Europeans. What works, or what might work in one place with one set of institutions, norms, and incentives might not work in another. We have many students at my school from abroad, and I warn them about taking American legal ideas home unexamined. Some ideas, even sacred ones, may not make sense everywhere. So if we hear today that legal persons don't work in country X or Y, I'll update, as a good Bayesian should, but I still may think BSPs are worth trying in my jurisdiction. Second, as I just suggested, I think the BSP is less radical than it sounds. In its minimal, cozy form, it is simply allowing the current board to act like a firm, to own assets, hire staff, build institutional knowledge, rather than being recreated every time there is director turnover. So this is a segue to my second idea, which is a little different, but I'll try to relate them to each other at the end. In my opinion, at least in America, we do a bad job at policing governance failures. One of the striking features of American corporate law is how much responsibility we place on markets to police bad governance. For decades, Easterbrook and Fischel taught that competition in products and capital and labor disciplines firms far more effectively than judges or regulators could. Firms that mismanage themselves are punished by experience. In that sense, the life of corporate law really is experience, not theory. But experience also teaches us the limits of that approach. Markets discipline many failures, but not all. Remember, most from that quote about Easterbrook and Fischel. And when governance failures slip through the cracks of market pressure, we rely, at least in America, on litigation brought by private lawyers. The trouble is that this litigation system is profoundly mismatched to the real pattern of governance problems. In securities fraud, we in the United States have both private plaintiffs and the government as enforcers. In core corporate governance, conflict of interest, loyalty breaches, sloppy oversight, the only police force on the beat is the private lawsuit. There's no public enforcer, no state law equivalent of the SEC, and no mechanism to bring cases where shareholders cannot or will not act. The predictable consequence is the wrong mix of cases. In some areas, for instance, mergers and acquisitions, there is way too much litigation. Every public company deal attracts, on average, 8 lawsuits in the United States, most of which settle for immaterial disclosures but sizable attorney's fees. These cases reflect incentives, not wrongdoing. They asked the famous bank robber Willie Sutton why he robbed banks, and he said, well, that's where the money is. In other areas where the governance harms are larger, we see no litigation at all. Private companies are more than 99% of Delaware entities, yet public companies account for more than 99% of cases, the opposite. Venture-backed startups, where governance conflicts between preferred and common shareholders are both common and consequential, rarely face fiduciary suits. Family-controlled firms oscillate between over-litigation driven by personal conflict and under-litigation derived by deference and family pressure. And in all these spaces, governance failures have spillover effects, distorting capital allocation, undermining trust in minority protections, and imposing social harms that shareholder litigation can't reach. So here's the second idea. Perhaps we could create a public enforcement option, a kind of corporate governance police force. The idea is not to replace entirely private suits, nor to criminalize ordinary business judgment, but to complement the existing tools. A state-level corporate governance commission, say, could investigate breaches of fiduciary duty, use subpoena power to uncover wrongdoing that private plaintiffs cannot reach, and bring cases that involve significant social harms, even when provable shareholder damages are small. Such an office could develop expertise across firms and industries, identifying patterns of governance failure that are currently invisible. Of course, any public enforcement regime carries risks, politicization, overreach, the potential to chill legitimate risk-taking. But Delaware's long track record and discipline of interstate competition provides some natural safeguards. Compared with our current system, simultaneously over-inclusive and under-inclusive, the potential gains could be big. Fewer frivolous lawsuits against large public companies, more targeted enforcement where governance failures really matter. The proposal is not a silver bullet, of course. Nothing in corporate law is. But in a world where private derivative suits often miss the mark and where vast governance failures go untested, a public enforcement option may be a necessary step toward aligning incentives, strengthening accountability, and improving the governance of American companies. Let me try to stitch these two ideas together briefly, drawing on my work as an expert in about a dozen corporate governance lawsuits. Although each case I worked on involved a different industry and a different part of the country, they were all depressingly the same. Corporate governance failures, in my experience, are sort of the opposite of what Tolstoy said about families. In Anna Karenina, Tolstoy said, "All happy families are alike, and every unhappy family is unhappy in its own way." In corporate governance, it's the opposite. Successful firms are often successful in their own way, while failures are eerily alike. The story goes something like this. An entrepreneur builds a successful business from nothing. He retires or dies, and the business passes to a second generation of children. One of them, often the oldest, takes control. The siblings complain. Their complaints are sometimes warranted, sometimes not. The eldest might not be the wisest. Even if the eldest is the best candidate, he or she may be greedy or distrustful of his siblings for reasons that have more to do with childhood rivalries than with finance. Distrust grows, sides harden, someone makes a rash decision to call a lawyer, and that's where I enter the picture. Flown in to testify on how not to do things and to collect a nice check based on their sibling rivalries. Having observed this market closely for 20 years, I can say a few things confidently. First, the number of instances of dysfunctional governance among family firms is enormous, and most of these do not result in litigation. This is the long tail that Bloom and his co-authors identified. Improving governance here matters enormously, not just for the individuals involved, but for the economies they operate in. Second, private litigation is a terrible way to resolve these disputes. In family firms, personal issues are interwoven with business ones in ways that are almost impossible to untangle. In a case I'm working on now involving three brothers in a multi-$100-million real estate business in Los Angeles, the deposition transcripts read like the script of a bad Hollywood holiday movie. Sadly, it's utterly typical. I've seen boards run by hippie trust fund babies who don't care about money or profits, board members who don't show or need to read their briefings, and laziness and corruption of every possible description. One could add many more examples, and I'm sure you have your own. A nightmare family case in which the founder's failure to separate governance from inheritance turns a successful business into a decades-long feud. The founder needed other options. The entrepreneur who built a real estate empire could have put a BSP in place at retirement to manage the business for his children, hired McKinsey Governance or Boards Inc. The children would remain shareholders and, subject to the voting rules in the charter, could fire the BSP, hire another one, or bring claims of breach of fiduciary duty against it. The BSP would be betting its reputation on choices to rent the real estate or not, to refurbish it or not, to sell real estate or go long. Having seen from inside how that company and dozens like it are governed, I can say with confidence that professional governance was sorely needed and, under current law, unavailable. In the absence of a robust BSP market, the private shareholder lawsuit is inadequate too. Siblings or minority shareholders generally are reluctant to sue. Law is messy and expensive. It makes few friends. Most people want to go along, even as they recognize that something is badly wrong. Going along is often good personal advice, but allows many bad things to happen. Suppose you see someone being mugged in the street. Most of us would not intervene. The law's solution is clever. We create something called the police, and we hire them to intervene on our behalf. They don't feel awkward or afraid. It's their job. The discomfort we feel about getting involved is, in a sense, outsourced. The same could be said for the BSP or policing the outer bounds of corporate governance. A BSP or a public enforcer could play for corporate law the role the police play in criminal law, stepping into situations where private enforcement is socially desirable but individually unattractive. In closing, let me connect this to a third, more speculative theme, what I'll tentatively call life cycle corporate governance. I find it odd that corporate governance is, in practice, one size fits all. The rules for a startup company are not materially different from the rules for the world's largest tech companies. Boards are boards. Fiduciary duties are fiduciary duties. The business judgment rule is the business judgment rule. This doesn't make a lot of sense to me. While some general principles should be stable, we should expect the operationalization of these principles to vary widely across firms, industries, and stages of the corporate life cycle. The kind of governance a two-person startup needs is very different from what a systemically important financial institution or dominant internet platform needs. Yet in the corporate contract, it is largely written at the beginning of life, when the firm's primary objective is raising money from investors and founders who dream of only one thing: exit. At that stage, outside judicial oversight is most unwanted and least valuable. The business judgment rule and the lack of shareholder safeguards are consistent with attracting investors whose minds are on a profitable sale. But that same corporate contract is less well-suited to the corporations that survive the process as the acquirers rather than the acquired. By the time a firm is doing billion-dollar mergers, employing tens of thousands of people, or mediating whole markets, the stakes are very different. The same permissive, low-oversight governance structure that once encouraged experimentation can now amplify risk and entrench power. So perhaps, alongside BSPs and a public enforcement option, we should consider explicit life cycle corporate governance, a world in which governance structures evolve as firms grow, consolidate, and acquire power. Governance might be the lightest and most founder-friendly at early stages. It might become more structured as firms scale and take outside capital. At large scale, or in systemically important sectors, we might expect more professionalized governance, like a BSP, closer scrutiny, and perhaps different enforcement tools. In mergers, especially in the end of a company's life, where hubris of humans and mistakes are significant concerns with big stakes, we might have the board fade away entirely, subjecting the decision to shareholder democracy or searching judicial inquiry. Gesundheit. Put differently, the contract of governance should not be frozen at the garage stage and then carried unchanged into the mega merger stage. Let me end where I began, with the idea of the academic pilgrimage. For centuries, people have come to universities like Vienna to test inherited ideas. Some survive, some are refined, and some left behind. The corporate board is, in some sense, one of our most successful institutional inheritance. But inheritance is not destiny. If the goal of corporate law, like all law, is to provide a framework for the maximum amount of human cooperation at the lowest possible cost, then experimentation is not reckless, it is a duty. Board service providers, a public governance enforcer, life cycle corporate governance, these are in some sense radical, but in some sense modest suggestions. They do not overthrow the corporate form. They don't abandon markets. They simply ask whether we can do better than a structure that would make Alexander Hamilton feel a little too at home. With that, I'll stop and look forward to any questions now or throughout the day. Thank you for your attention and your time.